Okay, good afternoon and welcome to everyone attending this afternoon's webinar. I'm especially pleased that we have three excellent speakers today. Before I introduce them, just a few points. Please use the Q&A button to ask questions, and I'll put these to the speakers at the end of the session. If we aren't able to answer all queries, we shall do so afterwards and send you the Q&A together with the slides and a link to a recording of the webinar. Now, you may be used to watching webinars in meetings mode where you're able to see each other. We're not using meeting modes today in order to minimize distractions and also to guarantee your privacy. This was most helpful, or would have been most helpful, if we had used that in a recent meeting where someone, I'm afraid, left abruptly, and I was very much hoping that they were going to the kitchen. And I was thinking, please, not the other place, I prayed. However, it was the other place, and as they entered the toilet, I had the awful dilemma of, shall I say anything because I didn't think the others had noticed, or do I put a stop to the embarrassment, which of course was being recorded. At some point in the near future, I'm sure that ITV will pay £200 for your best Zoom clips, but I was very relieved that she noticed before I had to intervene and the phone was quickly turned off. Anyway, on to the content. We shall be covering why and how the peer review system was brought in by the Legal Services Commission, as it was then. We'll be covering an overview of the peer review process. We'll look at what the peer reviewers specifically look for. We'll provide you with examples of good and poor practice and emphasize the importance of using high quality template attendance notes and letters. On to the speakers. I'm delighted that Professor Avrom Sherr has joined us. Avrom is the principal architect of a system of assessment of legal competence known as independent peer review. Since 2002, this has been used as the system for assessment of the quality of publicly funded work in the UK, ensuring the quality of legal services received by the public, and he leads the operation of this work. My colleague, Amy Higgins, is a senior solicitor, and she's also qualified earlier as a barrister. She is qualified under the Law Society's Immigration and Asylum Accreditation Scheme as an advanced caseworker and supervisor, and I'm pleased that she's also part of the team that sets and marks the supervisor assessment. In addition to working for us, she's been a consultant and training lead for ATLU. Amy specialises in all aspects of asylum and human rights work, with a specialism in anti-trafficking and modern slavery cases. We are also delighted to have Anna Skian. Anna is Head of Legal Practice at the Migrant and Refugee Children's Legal Unit. She is the Children and Young Person Specialist Solicitor and is a supervising solicitor on the Kids in Need of Defence UK programme, specialising in applications to register undocumented children with long residence in the UK. Anna also runs and supervises complex immigration and asylum cases for children and young people, and has been a consultant peer reviewer to the Legal Aid Agency in the immigration and asylum category since 2006. So welcome everybody, and we start with Professor Sherr.
Thank you very much. David, thank you for inviting me, and welcome to everyone for coming along and listening to this. I'm intending to try and explain how peer review started and why it operates in quite the way that it does. This, therefore, is the beginning of peer review. And those of you who are involved in legal aid right from the start of systems of quality will recognize, I think, this approach in which the Legal Aid Board, as it was then, and then the Legal Services Commission, thought that almost anything that was being done would actually show quality. And we were attempting to say that really it needed to be a lawyer's view of quality. We came up with something called the Quality Agenda in 1992. And we looked at things that I'm going to show you in a moment: input, structure, process, and outcome. We actually tried peer review, and we ended up with just transaction criteria. Many of you will have been involved in noting how transaction criteria worked, in which a non-lawyer actually looked at files and made decisions about whether your quality was good or not. But later on, in 1997 to 2000, we actually looked in a much more complicated way at both quality and cost. We had over 143,000 cases, about 83,000 were completed, and we carried out what in research terms is the gold standard, a randomized and controlled trial. We had different payment groups, and we had different systems for measuring quality. We had a statistical system called Briefcase. We had peer review, which of course you know we've ended up with. We had model clients and also a client survey. But all of these were related to what we were intending to look at. And that was an overall view of legal work divided up into inputs, structure, process, and outputs. Looking at inputs first, I think you will know all of these elements: the education of all your staff, the IT, the equipment that you have, the knowledge, the skill sets, and all the licensing. And the way in which that would be put together would be the structure, the management of your firm. Both inputs and structure were things that could be looked at under management quality systems for looking at legal work. But one thing couldn't easily be looked at in that way, and that was the process, the way in which you carried out your client handling, the advocacy, legal analysis, management of the whole process of doing the work, fact gathering, etc. So process was enormously important, but was missed out in those other systems of quality. And we also thought it was good to look at the outputs of legal cases, but unfortunately, almost impossible to measure in a simple quantitative, that is statistical way, what the outputs are, because each case is different. Each client is different. Each other side is different. Each judge or each chairman of a panel is different. And you need to be able to see the case in order to measure the output. So altogether, we found that one approach, which was peer review, managed to bring all of these items, all of them, into a consideration. So we carried out peer review in quality and cost. We looked at this number of cases over this number of suppliers, and you'll see this on the right-hand side. Selective breeding has given me an aptitude for the law, but I still love fetching a dead duck out of freezing water. Basically, our peer reviewers are, they've been selectively bred. They know about what law is and the work that you and they do. But they are in the position of looking at your work as independent persons. We found in quality and cost that these things were terribly important: selecting the right people, training them, having a set of criteria, measuring the right sample, and then monitoring cases afterwards. And we did all of that. We were worried about the reliability of our reviewers, inter se, that is between themselves, and of the instrument, that is the criteria we used. And we concluded that everything should be double marked and that we should look at whole organizations only. Well, we've remained with all whole suppliers, but matters are only double marked where there is a problem, that is where there is a 4 or a 5. We realize that actually what we're looking at is just an X-ray of a case. We do realize that, but we do feel that we can see quite a bit from the X-ray. we saw differences in quality and cost between solicitors and the not-for-profit. We saw 3 peer reviewers who were very different. One who always gave everyone good marks, one who always gave everyone bad marks, and one who always was in the middle. So we really knew that we had to train these peer reviewers. The result of everything was that, well, our lawyers didn't have much to hide, but we hoped that it was actually gathering what we really wanted. But we also sent out model clients to a whole set of particular suppliers. We weren't allowed to do much more than just have one visit and just one for each advisor. But what the model client work showed us was that there are things that clients see and feel, and they don't in any way give us a full understanding unless you get into the minds of model clients. There was initial contact, which was difficult in some places. Getting appointments was difficult in the advice system. And there was very little certainty in terms of the advice that they felt they were getting, that is, the model clients. So looking at everything through the view of these clients, the advice that they were getting was inaccurate, impractical, woolly, confusing, contradictory, and it was inappropriate. That was a very important thing for us to see. We realized that clients needed to be told properly and very clearly what the advice was so that they could be involved in making decisions in their cases. However, we also saw this, that model clients, the clients, let's call them, could see some things. The advisor showed an impressive level of concern for my job security. Overall, he was very helpful, reassuring, and personal. But when we actually got the peer reviewers to look at that same case, this is what the peer reviewers said. Although very clearly empathetic, this advisor does not really know enough about the law to be using legal aid money. A good example of touchy-feely advice. So what was necessary was to find a system that would actually do what clients wanted, what model clients found, and it could also consider the outcome measures and the financial results and everything that happened in court if we brought it all together under peer review. And that's what we've done. And it's been done in a way, and we've been promised this always by the Legal Aid Agency and previously the Legal Services Commission, that cases would be taken at random as well as targeted. In other words, where the Legal Aid Agency might think that there is a problem, but also just at random. We've had that all in all. Sensitive implementation we asked for, and it certainly was for a number of years, a sensitive implementation. But it was very different from the cost, the compliance approach, and also the transaction criteria. Though there is a certain element in which it feels like your belts are tightening, and we understand that because it's peer reviewers, peers, who are looking at your work. So these are the things that we found were most important. That is selection, which is something we do very carefully. Training, we do a lot of this, and our peer reviewers can't just do the work even after about 6 months or so. They still need to be watched carefully. We have criteria. I will show you some of them in a moment. It is the Legal Aid Agency which choose the sample, but it's the peer reviewers which give the makeup of the sample that they're looking for in each area. And then we have monitoring of all cases. And of course, as I've said, no peer reviewer goes out knowing that what they're going to see is targeted, a problem area. All they know is that it could be random and it could be targeted. And that we think is a good thing. This is therefore the whole world of peer review in operation. And I'm sure you know that it's been used for a large number of areas. And here are some of them. It's been used for the consistency in general. It's been used for preferred suppliers at one case, at one stage. It's been used for peer reviews of peer reviewers. They all have to have at least a 2 if they're going to continue as peer reviewers. I thought I would show you briefly the civil side criteria. The crime side is different, but it is in the process paper, as is almost everything that I've told you now. Here are the gradings. I think you'll recognize them. Excellence is at the top. We don't get too many excellences nowadays because I suspect you're not being paid enough to deliver excellence. At the bottom is failure in performance, and thankfully we don't get too many of those either. But in between are competence plus, competence, and below competence. So this is the way peer reviewers look at things. They give 1, 2, 3, 4, 5, or 1, 2, 3, 4, 5 not applicable, or a yes and no, and further comments to all of these criteria. And here they are, briefly. The first section, A, is communication with the client. How well does the advisor appear to have understood the client's problem? How effective were they? Were the advisor's communication and client handling skills? How effective were they in fact information and gathering skills? How effective was the client informed of the merits and all developments? So I think you can see that we got from all the work that we'd done in quality and cost research, the necessity to explain things clearly to clients and make sure they understand. But we also saw that cases were changing in the early 2000s, and that it was very rare that the same lawyer carried the whole case through from beginning to end. So files needed to record everything, including that communication and this advice. How legally correct was it? How appropriate was it? How comprehensive was it? And was it given at the right time? And then we look at the work, and there might not be any further work, and that might be appropriate. But if further work was carried out, how well was it done? How appropriate was it? How effective in working towards what the client reasonably wanted and needed? And about disbursements, how well were they dealt with? Where this is necessary, did the advisor consider on an effective referral? Throughout the file, how did the organization use resources? Did the advisor or their work in any way prejudice the client? We didn't have this in right at the beginning as one of the criteria, but it was suggested to us by reviewers that that was necessary. And sadly, in about 9% of cases, they actually see the possibility of problems. Here's the family extra criteria, and finally the overall mark, which is, as you know, 1, 2, 3, 4, or 5. There is also specific guidance which is mentioned in the process paper, written for reviewers by reviewers, and that's really all that I'm going to talk about today, but we'll be very happy to talk to you in relation to any questions and answers that you put down for me. Thank you.
Thanks very much, Avrom. It's my pleasure now to introduce Anna.
Thank you, David. I'm one of the peer reviewers that carries out reviews in the immigration and asylum category, and so I'm going to talk to you a little bit about what we look for as peer reviewers. One of the things that we've done as a group of peer reviewers, as have all the different category peer reviewers, is written an improving your quality guide, and that does set out what we look for in overview. I would recommend giving it a read. Unlike the civil contract and the immigration specification, it's not long and it's quite readable. So I would suggest that it's a good place to start. It sets out what we are looking for, and it tells you what we think is important. Overall, we're looking to see whether you have provided competent representation and have added value by your involvement in the case. So we're peer reviewers, which means that we're also immigration practitioners just like you. It means that we know that it can be difficult to represent clients in the asylum and immigration process. It also means that we know what can be done and what should be done. Asylum and immigration clients are some of the most vulnerable clients in the legal system, and the stakes involved for them are high. Where legal advice is inadequate, there is a risk to their lives and their fundamental freedoms. So this is something that we always bear in mind when reviewing files, that the stakes are high for the recipients of this advice. We're conscious that asylum and immigration clients may not be aware when they've received poor advice, and that even if they become aware, they may be removed from the UK in consequence of that poor advice before they have any mechanism to challenge. So we need to protect their situation by ensuring that the advice given in public funded legal advice is competent and accurate. However, we're not holding you to standards that we don't apply to ourselves. As Avrom has said, all peer reviewers have to go through a peer review of their individual caseload themselves, and we must achieve a score of competence plus or above in order to be able to review. So I would say that we don't have unrealistic standards, we have appropriate standards when we're looking at your file sample. So what do we as peer reviewers think that competent representation means? It means providing good quality, comprehensive and correct legal advice. So when we look at the advice provided, we do that as set out in the quality guide. Is the advice correct? Immigration law, as you all know, changes frequently, and it's essential that those providing advice are providing the correct advice at the time that it's provided. We want to know if that advice is comprehensive. Are all of the client's options explained clearly? Does the client know, has they been given enough information to understand what types of evidence may assist their specific application? And has the advice that's been provided been reviewed regularly during the life of the case? With the frequency of changes to law and the length of time it can take the Home Office to make a decision on an application, are you making sure that changes to the law are addressed and further submissions made if relevant? We want to know whether you're acting on your client's instructions and in their best interests. We want to be sure that you're providing advice on all of the relevant matters in a way that your client can understand. So we look at the way that you're communicating with the client, making sure you know who your client is, that you're adapting your communication to address their particular needs, perhaps because of their age, sex, health, language, or the fact that they may be detained. And we're looking to see whether you're in relatively reasonably frequent contact or regular contact. We're also looking at the preparation of your client's case to make sure that that's to a standard that has the best chance of obtaining the outcome that the client needs or wants. So we're looking at the work that's been done. Is it appropriate and effective? Have you taken a full immigration history from your client so that you have sufficient information to make sensible choices about what needs to happen? Have you noted key dates? Have you obtained all of the key documents? Have all of the necessary actions to progress your client's case been identified and actioned? Any legal submissions that you've drafted, are they up to date? Are they relevant to your client's case? Do they make sense in and of themselves? Are your bundles relevant, up to date and well organized? Have you considered the need for expert evidence? Have you considered the need for other supportive evidence and taken steps to obtain it? Have you considered the need for witness evidence? Have you pursued that witness evidence? Have you briefed any advocates, whether they're in-house or external, properly? Do they know the case sufficiently well to be able to present the client to the best of their abilities? Have you reviewed the work undertaken by external parties? Whilst you can't tell the expert what the content of their report should be, you are able to work with them to ensure that the presentation of their report makes the content as clear and intelligible as possible When you're dealing with Home Office caseworkers, they're not necessarily trained lawyers, and you need to support them to understand how your client meets the requirements of the immigration rules. Have you made any appropriate referrals for additional advice, particularly in the situation for a child where they may have any conflict with the local authority? There is a contractual requirement that a referral is made for community care advice. Have you identified the correct or appropriate method to challenge any refusal? So are you able to identify whether the mechanism for challenge is an appeal or an administrative review, or is the only option judicial review? And we also want to know that you understand the public funding that you're administering, that you understand what's in scope, what's not in scope, that you're not providing out of scope work without an exceptional case funding application. Do all staff know about that process, that it's available? Have you advised your client where exceptional case funding is available, even if you're not able to provide advice yourself pursuant to exceptional case funding? Is merit controlled legal representation, is that assessment being undertaken appropriately, and is it being communicated to the client appropriately? And is there evidence that you understand the boundary with licensed work and when you should apply for a public funding certificate? So I talked earlier about adding value, and that's something that we look through across the file sample. What does it mean? Have you increased your client's understanding of the process that they're undergoing in a meaningful way? Have you explained the legal process? Have you explained the legal tests that will be applied in language that makes sense, that means something to your client? Have you checked with them that they understand what that means? And have you explained any action that they or you may need to take to improve the prospects of their application succeeding? This doesn't mean sitting in an office and regurgitating the Geneva Convention word for word and telling them about the names of specific cases. It means the nuts and bolts of the information that they need to make a practical difference in their case. We want to know, have you assisted your client to participate in the process to the best of their ability? Have you taken a full history of their experiences so that they can explain the basis of their application? Have you tested their account by asking further questions or querying inconsistencies? Have you identified any particular vulnerabilities that your client has and considered how they may prove obstacles to their explaining their case? Have you considered whether additional evidence may assist to explain those obstacles? Does your client know the staging points in their application, interviews, submission dates, opportunities to submit further evidence? We ask, have you increased the quality of the evidence provided to the Home Office in support of the application? Have you considered taking a detailed statement from your client to enable them to explain their experiences in a less stressful setting than the full asylum interview, for instance? Have you obtained evidence to support any physical or mental health problems or the sequelae of ill treatment? Have you sought additional objective evidence that corroborates your client's case? Have you asked your client whether there are witnesses to any of their experiences who would be available? And have you contacted those witnesses and obtained evidence translated if necessary? Sorry, I've gone ahead with the slides. Have you used your skills and knowledge to put your client's case forward in the most advantageous way for them? So have you drafted legal submissions which are specific to your client's case? Explain why they in particular meet the requirements of the relevant immigration law by reference to the evidence that they or you have prepared. Have you ensured that the Home Office has applied up-to-date and correct law and policy? As peer reviewers, we don't just look at the outcomes in your case and award a mark for how many successful cases you have. That's not how it works. We look at whether the work that you have done has contributed to the outcome of the application. And so you could, in theory, submit 12 files where every client's application has succeeded and still have your work found to be not meeting the requirement for competence, where you didn't contribute anything to the outcome of that case. We do occasionally see file samples like that. As immigration practitioners, we know that sometimes it's the cases that are refused that are the ones that showcase your work, that show that you've tried everything possible, because we know that the system doesn't always allow cases that we would have liked to have granted. What we want to see is that you've engaged with your client's case and given it the best chance. So in terms of demonstrating that you've added value, the most important thing is that you ensure that your file is an accurate reflection of everything that you've done. Rule of thumb is if it's not on the file, it didn't happen. So if you've done a lot of work to try and obtain something, to try and explain something, record that in your attendance note, record that on your file note, make sure that it's clear that that's happened. If you've encountered problems, set out the problems that you've encountered, document them, but also document the steps that you've taken to overcome them. We don't expect perfection. We all know that things happen that are beyond our control, but we do expect you to take steps to resolve any issues that arise. Use templates and standard documents. They can be really useful, but they're not an end in themselves. It's a very different thing to have a prompt sheet that reminds you that you have to advise a client on specific issues or obtain specific important key information, but it's a whole different one to just have a list that is put on every file but isn't engaged with in reality. If your attendance note is just a list of information you've provided, then if I'm reviewing, I'm wondering, what did your client say in response to that? What were the instructions you got in relation to those aspects? And if you haven't recorded any instructions, what do you know about your client's application? Communication with your client is essential. It needs to be meaningful for them, and not just a roll call of all of the main cases on a particular aspect of immigration law. Your client doesn't need to hear chapter and verse on the different paragraphs of the immigration rules or specific cases. They want to know what they have to show in order to make an application that will be successful. You need to let your client know the strengths and weaknesses in their case, and where there are weaknesses, you need to discuss with them what might be appropriate to try and resolve those weaknesses. You need to show that you're adapting your approach to the needs of each client, tailor your letters, tailor your submissions, use an appropriate interpreter, make sure that you consider whether the gender or ethnicity of the interpreter may have an impact on how your client is able to engage with them. Consider whether either for the whole case or for certain aspects of preparing a case, a different staff member within your team might be more appropriate because of their gender or other factors. It's really important that you engage with the Home Office and any correspondence that you receive from them in an active manner that progresses the case effectively. One of the things that really peer reviewers find very, very difficult is where a legal aid provider is effectively just a really expensive post box. Letters come in from the Home Office, are sent out to the client without any explanation, any mediation. I have seen cases where on every file, a provider sends out a letter to the client saying, please find herewith a letter from the Home Office, the contents of which are self-explanatory. Largely from experience, the letters from the Home Office aren't self-explanatory. And also, if they are self-explanatory, what are we doing? They might as well take away immigration and asylum legal aid if none of the things that the Home Office provide require explanation. So it's essential that when you receive a letter from the Home Office, you look at the contents, you analyse what that means for your client's case, and you explain it to the client and advise them of any action that's needed accordingly. So how do we undertake the review? We are provided a box or several boxes containing 15 files. We're also given a file list. We must review the first 12 files that are on the list. We can only move on to the reserved files, if there's anything about the first 12 that renders them unreviewable, perhaps because the file isn't complete, or it turns out that one of the files isn't actually a legal aid file, or other technicalities like that. We treat each file separately and we provide a rating for each file. We really want you to pass, and we start off our review assuming that you will. We do, however, consider the file sample as a whole and provide an overall rating of the work on the provider. Anyone can make a mistake. We don't expect perfection, but making the same mistake 12 times on every single file is a different matter, and it provides an impression that you don't know the correct way to deal with that particular aspect. Given that anyone can make a mistake, the way that you put a mistake right is really important. So we also look at evidence on the file sample of whether their file review is taking place within the provider's practice, and what evidence there is on the files of that being a meaningful process rather than a tick box exercise. So for example, for my own organization's peer review, the reviewer identified that one of my colleagues had sent out a closure letter which had incorrect advice in it. But rather than saying that that was a negative point, the reviewer noted that in a file review, their supervisor had identified that, explained the problem, and the caseworker had written a different closure letter and made sure that the client had the correct advice. So although there was a mistake on the file, the way that we dealt with it was a positive, because it showed that we had a system of checks and balances and that we worked as a team to ensure that clients had everything that they needed. We will look at the impact of any mistakes on clients and the extent to which a competent advisor should have known. And we'll weigh the balance of the nature of the work undertaken, so that if you're able to provide threshold competent work on straightforward cases, but your complex work is universally done to a non-competent standard, then we will look to protect those people who have complex cases, and it's likely that consistent evidence of an ability to run complex cases properly will be given considerable weight. And we also look at the impact on clients for whom the impact is worse, so detained clients, children, and particularly vulnerable individuals. When we draft a report, we do so with examples to explain any issues that we've raised and to explain the rating that we've given. It can be hard to hear criticism, but it's a really important part of the process that you engage with it. I know personally that, the reflex is to dismiss things that we don't particularly want to hear, but we can only improve if we don't dismiss that criticism, if we engage with it, take it on board and endeavour to do better. And at the end of a report, peer reviewers will usually provide some suggestions about how to improve. And I would ask that please don't let your dissatisfaction with negative comments prevent you from engaging with those suggestions, taking them on board and thinking about how you can improve your practice. Thank you.
Okay, thank you very much indeed, Anna. That was a very absorbing and interesting session. So I'll now hand over to my very popular and esteemed colleague, Amy Higgins.
Thanks, David, and good afternoon, everybody. Thanks for joining us. So the points that I wanted to really make to you today come from my background and my role as an immigration practitioner, and also as part of my role at DG Legal, where I'm getting to see huge numbers of peer review reports, positive and negative ones, and I'm frequently instructed by firms to help them improve their practices, so to develop better precedent letters and file notes, template documents, or to help them to challenge a negative peer review where they feel that those findings are not sustainable. And through having seen so many examples of these reports and seen so many different firms' files, I feel like I've been able to gather quite a good collection of pointers for you in terms of good and poor practice. And I wanted to outline some of those for you today, and hope that this really helps you know and understand what they are actually looking for from a practical point of view. I think, as Anna has really clearly set out in what she was saying earlier, each file needs to be a very detailed record of absolutely everything that's happened on that file. If you haven't recorded in file notes or letters or notes on the file, you're thinking behind actions that have been taken, you're thinking behind any actions that have not been taken, and details of all advice that's been given to the client and all instructions that they've provided you with. If it's not on the file, as Anna said, it's taken to have not happened. And I think that's one of the issues that comes up an awful lot, where I will say to firms, you know, there's no evidence that you've really discussed whether or not there's any supporting evidence, for example, and clients will come back and say, well, of course we've discussed it, there isn't any, but there's no evidence recorded on the file of those conversations having taken place. So I think we cannot highlight enough how important it is to have detailed file notes that set out everything that's absolutely happened on the case. These are the positive things, I guess, that you tend to find on files that are scoring, you know, 2s and 3s, and sometimes 1, the rating of excellence. Those files do detail everything that happens, and it's clear that the case is being progressed quickly and appropriately, and the client's being kept informed at all times of any developments on the case. It's always a contentious area, I think, with immigration practitioners as to whether or not we should be preparing and or submitting a witness statement for our clients. There are clients who will say, I don't want to submit a witness statement, and there'll be clients who say, I absolutely want to prepare a statement, but I don't want to submit it to the Home Office before the interview takes place, or indeed at all. That doesn't mean that you shouldn't prepare a witness statement. It can be one of the best ways of accurately recording a client's instructions. So if a decision is made for whatever reason not to prepare a witness statement, it's still absolutely crucial that you have a way of accurately recording all the details of the client's instructions on the file. It's absolutely fine to prepare a witness statement and discuss with the client the pros and cons of submitting that to the Home Office, either before or after the interview. And there's no need to actually submit the statement before the interview if you feel that that would in any way negatively impact the client. For example, if you feel that they will be overwhelmed by questions, or they may contradict what they say in the interview, you may feel that it's a better way to approach the situation by preparing your statement before the interview, so the client knows the types of questions that they're likely to be asked, and they've had a practice at discussing their case with you in detail. And then you can deal with the statement, finalising the statement and dealing with any issues that may have arisen in the Home Office interview by completing that statement after it's taken place and submitting it as part of your further representations or corrections to the interview record. I think it's really important that there's evidence of having analysed all of the available evidence. So you quite often see files where the Home Office will raise in a refusal letter, or indeed in a Home Office interview record, that the client said different things at different stages of their claims. So, for example, inconsistencies between screening interview and substantive interview. If the provider has on their file, which they should have, a copy of all the documents relating to the case, it's important that there's evidence of some forensic analysis having happened, so that you've compared the records, you've looked at them, you've discussed them with the clients, and you've picked up on any weaknesses in the case or any inconsistencies that you can then discuss with the client and put forward an explanation wherever that's possible. I also feel that the better cases are clearly evidencing the importance of the role of the legal representative. Again, Anna was saying this. It's really crucial to show the role of the legal rep and the value that you've added by being involved in the case. So you're not acting simply as a post box by passing on information between the Home Office and the client, but that you're actually strongly advocating on their behalf. One of the ways that I think a lot of providers fail to really do that is in dealing with post-interview corrections or submissions. What I tend to see quite a lot is a letter going to the Home Office saying, here are the corrections that we'd like to make to the interview record. At question 35, it should say this. At question 36, it should say that. At question 37, my client would like to add this. What they failed to do is to really go on and put forward strong legal representations to say why the client meets the definition of a refugee, why there is no sufficiency of protection for them, and why an internal relocation within their country would not be possible. They don't put forward all the strengths of the case in relation to supporting country information, country reports, and there's a lack of engagement with supporting case law quite often. You'd expect to really see post-interview representations definitely putting forward all of that information to the Home Office and really fighting for the case and fighting for your client to be successful in their claim. The other really good files that I see are where appropriate referrals are made, and that would be, for example, to medical professionals, to other experts, country experts, for example, to document scarring, for clients who've been victims of torture, to put forward an appropriate referral quickly, because these things do take time to prepare. So it's really about, as we said, evidencing everything in a clear and concise manner on those files. And it's important not only to serve as an accurate record of everything that's happened on the file, but it's important to remember, again, as legal aid practitioners, that you can charge for this. This is, you can charge time for the preparation of your file notes, you can charge time for engaging with the documents, considering all of it. And I think what I see is that the time recording on a lot of people's files is fairly low. And it's not that they're not spending the time doing these things, but they're not actually making a time recording charge for having done it. So it's important for good practice, and it's important to make sure that you are maximising costs wherever you possibly can. A few examples of what we see as negatives on files would be the overuse of standard documents. And it's always the same thing that jumps out at me. Many firms use standard documents, so standard letters and template file notes. And from my perspective as a practitioner, I think you absolutely have to have a bank of precedent documents to save you time and to act as a prompt to make sure that you are advising clients on particular areas so that they're not, you don't forget to take instructions on a particular point or to advise on a particular point. But where you adopt a bank of standard documents, you really have to take responsibility for making sure that they are accurate, that they are appropriately amended, and that you review them regularly, because the law changes and the procedure changes so quickly that it's very easy for any type of standard to quickly become inaccurate, and therefore you've got inaccurate information on your file. And if it's written down in a file note, that you've given a particular piece of advice to a client and that's not accurate, then of course that's going to cause issues for a peer reviewer when they're looking at it. With the use of standard documentation as well, if you fail to tailor your advice specifically to a client so that it's useful and it's meaningful to them, if it's just generic advice that is the same on every single file, then it's going to call into question whether that advice was in fact given to a client. And you have to ask yourselves whether that is actually useful to a client. And an example of that would be something like, if you have a standard file note that advises on all possible outcomes to an asylum claim, being a grant of refugee status, a grant of humanitarian protection, a grant of discretionary leave, and also a grant of leave to remain in the UK for an unaccompanied asylum seeking child. If you leave all of those potential outcomes in, then it looks as though it's less tailored. If you leave advice in that would be applicable to a minor client for an adult client, again, it looks like it's just a standard document and that advice hasn't actually been given, because there's no need to give an adult asylum seeker advice that it's applicable only to a child, for example. We find that there's a lack of information given to clients about the merits of their case. And that's really important as well in terms of managing a client's expectations. if they're able to understand that obtaining supporting evidence would really help their case, and you can give them assistance in how they might go about obtaining that evidence, you've given their case the best possible chance of success, and the client is able to understand the prospects of being successful with relation to the current case law and current country information that we have available. It's about explaining that to them in an accessible manner. I've already touched on witness statements and the importance of that. In terms of negatives, we see a lot of witness statements that are really kind of taken as a box ticking exercise. Oh, you know, we need to do a witness statement, so we'll draft a witness statement. And they're very brief. They are drafted in language that appears to not be the client's own words. So again, that calls into question whether a precedent's being used and whether the client is in fact giving you those instructions that you are then documenting as part of the witness statement. A statement needs to really engage with the issues in the case and provide plenty of detailed information in order for it to be useful. So a standard witness statement, or one that isn't in the client's own words, just isn't useful. It needs to be a very meaningful and useful document that supports the case moving forwards. Similarly, in terms of the legal reps, I've already touched on that, and it's mainly the representations that are post-asylum interview that I think seem to be lacking. But of course, you'd expect to see detailed legal reps throughout the life of a case where that becomes applicable. In the files that I've seen, particularly of late, there tends to be a lack of evidence of representatives seeking copies of screening interviews and going through those methodically with the client to check the detail that's contained within them. I know from my own experience, where you don't have a copy of the screening interview at the outset, it's incredibly important to get that quickly and go through it. It tends to be the document that always comes back to cause you problems further along the line. So starting from the very beginning, you need to be looking at the evidence that's available, going through it with the client and checking for inconsistencies. Where there are inaccuracies, they need to be promptly amended. Similarly with completion of a statement of additional grounds, that doesn't seem to be something that happens routinely on the files that I've recently been looking at, and it is of course an important part of the procedure to put forward to the Home Office. Just a few more negatives, because I unfortunately pick up on more negatives than positives, and I don't mean that in a discouraging way. But I think missing deadlines is something that is obviously really important. Key dates need to be identified on the file and in a central diary, as I'm sure you're aware. But the importance of not leaving things till the last minute, so appeal deadlines or submission of bundles. You need to be proactive in preparing cases, and so that clients are able to engage meaningfully with the process rather than leaving things to the very last moment. It's much better to give clients an idea of timelines and how long you have, rather than leave things to the very last minute, which causes them to panic and be worried. In terms of failure to identify issues and risk factors, again, I think a lot of the times that I've reviewed files and these things are not evident on the file, a lot of it is down to a failure to document issues and a failure to really kind of explain to clients that there are additional issues that might be applicable, and to go into those in more detail with them, particularly where there are elements, for example, to an Article 8 case where you know that it's out of scope, but there needs to be advice to the client about the availability of exceptional case funding, rather than attempting to do little bits of that work pro bono, or simply saying to clients, unfortunately, I can't assist you with that element of the case because it's no longer in scope. So really important to document every conversation that you're actually having, not necessarily in huge amounts of detail, but certainly at least in bullet point form, so it's evident that those conversations have taken place. Another important issue is having evidence of file review on the files. Now, I don't necessarily just mean formal file review as you're required to do by your quality standard mark with your Lexel or SQM, but evidence that the file is being reviewed on an ongoing basis by the fee earner and or by their supervisor. And that's really important. Again, you're not expected to be, I think the term is a walking law library. It's fine for you to need to go through the file, remind yourself of the facts, remind yourself of what's happening, and put some sort of evidence on the file to show that you actually have gone through the file, you've checked the deadlines, you've checked the evidence that's available, and you're refreshing your memory really in terms of preparing the case and what you need to advise the client in relation to. So it can be a simple file note of just a few lines saying, reviewed the file, checked the evidence to date, next steps are as follows. And that will enable you to go back and look at what's been done so far, identify any potential issues that you can then have an opportunity to correct moving forwards. So going back to what I had said at the beginning about the importance of having standard documents and template prompt attendance notes, I guess. Everyone will take a different view on that. I personally feel that they are really important because it saves huge amounts of time in terms of serving as a prompt, saves you lots of time in typing lots of things out, but you have to be aware of the need to really amend them and tailor these documents. There's no point in having standard documents if you're just going to stick them on the file as is, because it has the effect of every file looking as though it's exactly the same and that you haven't meaningfully engaged with the facts of each individual case. So they do have to be amended and regularly checked and regularly updated. Probably poignant at this point to say that this is something that we offer at DG Legal as a service. We would work with firms to help you streamline your processes and help you draft useful documents and template letters and file notes if you feel that that is useful. We work quite closely with our clients to work out what's best for them and what sort of assistance they need to really drive up the standards within the practice. So if anyone does have any queries about that, please do contact us or let us know. I think that's really all I can usefully say in terms of useful tips and tricks. But if anybody does have any specific questions, again, as Avrom and Anna have said, very happy to deal with those when we finish the webinar. Thank you very much.
Okay, thanks very much indeed to all three speakers. Now, we do have quite a few questions. Now, it is 2 o'clock, but I think we should spend 10 minutes. If people watching need to dash off, that's absolutely fine. This is being recorded, etc. But let's have some questions. If we go to the Q&A box, there are some questions there, but someone has sent one to me privately by email, which I'll kick off with. And the question, which I can easily answer, is if I get a score of 4, when I'm reappraised, is the best score I can get a 3? And the answer is no, because the second review is carried out without the peer reviewer understanding that a previous review was carried out 6 months previously. So the score could clearly either be 1, 2, 3, 4, or 5. So that was quite an easy one to kick off with. Some of the other questions are a little bit more challenging. So let's have a look at the first question here. We've got one about file notes being electronic. So the question is, what is expected of firms that has its file notes online? Do we need to print out the file for peer review, or can we share by desktop? And I'll give that one to Anna. Just need to answer.
Okay, so we can undertake peer reviews on electronic files or on paper files. And I have undertaken reviews where part of the file is paper and part of it is electronic. What I would say is it is the responsibility of the provider to ensure that they make clear in what format they're submitting specific files, and make sure that they send everything from that file to the peer review team so that it can be sent to the reviewer, and the reviewer has a full picture of each file.
Okay, thank you. There's another question which is really quite similar, which is, what are the arrangements for peer review during COVID times? Are files being submitted physically or electronically? If your organisation does not have a fully electronic file system, can you submit email attachments with different documents?
I think that's kind of more of a process question that the peer review team that deal with handling incoming files and outgoing files would have to answer. Peer reviewers just review what they're given. We're simple folk. So during COVID, I have reviewed physical files, but that was because they were delivered prior to lockdown. There was a pause during lockdown. My understanding is that we've now started again, but I can't answer the specific questions about how the files are provided to the legal aid agency.
I can answer just a little. There's no difference in relation to COVID times. The files, which are mainly physical, but can also be electronic, as Anna has said, the files go through being sent to a central process office, and then they get sent on to the peer reviewers. This takes at least 3 days, and 3 days is considered to be the time that's necessary for any files which might contain virus to be completely decontaminated. And so there isn't really an issue. If that was the issue that you were talking about, that's not a problem. In relation to the difficulty of doing work at all during COVID, peer reviewers know particularly for themselves exactly how difficult that has been, and it is the rule that we take that into account.
Okay, thank you for that. Next question, which I'll ask Amy to comment on first and then ask Anna if she has any further comments, is it going to be sufficient to record file notes and developments on the file in bullet point style?
I think you'd want to see a little bit more detail than solely bullet points. I think you'd have to have a lot of bullet points probably to cover all bases. I don't think there's any reason why you can't supplement a detailed note with bullet points, but on the whole, I think you'd expect to see a little bit more detail, certainly in terms of the instructions given by the client or the advice particularly given, the tailored advice given to the client in relation to their particular case. I guess a mixture would be my answer. That's how I generally tend to approach it. You can bullet point general information where it's a bit more specific and a bit more detailed. I think it would need to be drafted as a normal document. Grateful for your views on that, really, Anna.
Yep, meet.
I would agree with what you said, Amy, yeah, that there may be limited circumstances in which a short bullet point list in the context of a more narrative note will be sufficient, but in general, if you want to use your file note as an evidence of the advice you've given, it should provide a level of detail.
And I'd just like to add to that, really. Yesterday, I was running an immigration supervisor's revision course, and a number of those delegates that were there yesterday are on today. And one of the points that I was making was that I find it a little frustrating that the overwhelming majority of legal providers only get paid graduated or fixed fees under the remuneration arrangements. And there's a small minority of firms, which I would estimate at 5%, that are fully maximising their fee income by getting many, if not most of their fees into escape fee territory. And Amy, for instance, used to run a firm where she got pretty much 100% of her cases into escape fee territory, and there's other well-known firms that do that. And that really can make the difference between financial viability and not being viable. So I'd strongly encourage people to really understand and learn the cost guidance in order to give yourself the best chance of being viable. And I mention that because if you're just going to use bullet points, you're never really going to get into escape fee territory. You need to have detail. Okay, next question. If a file has been assessed by the escape case team, will it still be peer reviewed or excluded from the sample? Well, I can answer that very quickly. it makes no difference whether it's an escape fee or not. The peer reviewers simply will not know whether it's been assessed as an escape case fee. So no, it makes no difference is the answer. Next question, what is the current timing for requests for peer review depending on what grading you've had before? Is the peer review team experiencing a backlog because of COVID? And I think that's probably for Avrom.
Hi, Karita. It's more complicated than that. There is an approach which looks at a certain number of reviews each year in each area. So it could be that there are only likely to be 20 or 40 or 60 reviews in a particular area. And then it will be a matter for the legal aid agency to decide which suppliers should be looked at on a random basis and which suppliers should be looked at on a targeted basis. It's quite possible that you won't get a review at all within a period of 2 to 3 years. If you've had a review and you've got a 4, then you will probably be reviewed within 6 months to a year afterwards in order to ascertain whether you've got better than the 4 during that period. COVID will give some backlog, but the truth is that because there were less cases during the period of COVID, the backlog will probably not be quite as much as a problem as it is in the court services.
Okay, thank you. Now, I guess this next question really relates to something that Amy was saying about witness statements, but I'm going to ask Anna to comment on a specific question. The question is, I'm a former peer reviewer. It used to be our policy that a witness statement was not required as long as there was detailed evidence of the basis of claim on file, for example, the file note or the initial attendance note. Will this no longer suffice? Realistically, a witness statement is often not financially viable. Our rates have not increased since the PIQ was introduced, so a lot of firms are still refusing to complete them in detail. Anna.
Peer reviews have never had a policy that a witness statement must be taken, but as Amy said and as I've said, it's essential that sufficiently detailed instructions are taken from clients in order to understand their basis of claim and to be able to articulate their claim when you're making submissions. So whether the instructions taken are drafted into a formal witness statement or remain on an attendance note, provided they're in a sufficient level of detail to allow you to accurately and fully represent your client, the peer review just want to see that you understand your client's case in sufficient detail and at a sufficient level to allow you to competently represent them.
Yeah. Now I think we've got 3 or 4 more questions. I'm conscious it's just after 10 past. So I'm going to just take one more question, but we will answer the other 2 or 3 afterwards. The question here is the Improve Quality Guide. And I should say that in relation to additional notes on top of these slides and this recording, the best place is the peer review process document together with the Improve Your Quality Guides written by the peer reviewers. Now this question here is, the Improve Your Quality Guide is dated 2016 and it does not take into account the changes of the 2018 civil contract. My peer reviewer marked me down for not issuing a CW4 at the end when upper tribunal work is licensed work and does not fall under CLR refusal. I do follow that. Anna, do you follow that question? I pretty much do.
I follow the question, but it wouldn't be appropriate for me to comment on specific peer reviews in this context.
Yeah, I think really your only opportunity to challenge that is if you had a 4 and that would form part of the representations.
Can I just say something about the quality guides? They have actually been updated. But our dear friends at the Legal Aid Agency have taken some time over the production of a new process document, which will include the quality guide. So unfortunately, the latest version hasn't actually been published yet. That is a fault. And we're hoping at any moment that they will actually get it together to manage a new process document, and that will include the updated guides.
Okay, great. Well, thank you to all of the speakers. The last thing I'm going to finish on is, if you have enjoyed this afternoon's webinar and you want to get more of these free webinars from us, we would be enormously grateful if you could consider either leaving a Google review or a Facebook recommendation. And if you do take the time to do that, in return, we'll provide you with a free peer review friendly file review pro forma. And we'll also let you know as soon as the peer review process document and quality guides have been updated, and we'll send you links to all of those guides. So once again, thank all of you for attending and taking the time out, and a special thanks to, I think, the speakers who have been absolutely fantastic this afternoon. So thank you and goodbye, and we'll be in touch shortly with the full questions and answers. Thank you.